Immediately after an injury, you should seek medical care. And assuming you've stabilized the condition of the injured, the next priority should be documenting your case and gathering evidence. There's a variety of evidence that you could collect at the scene. The problem is, and it's understandable, that at the time of an accident, the adrenaline's flowing, and it's not really the most natural thing to do to think that you should begin interviewing witnesses. But at the very least, take scene photographs with your camera phone. Ask people for their name and information or their business cards. Be sure to call a friend who can come to the scene and help you gather such evidence. Identifying witnesses, don't rely necessarily on the police report or the investigating officer. Take aggressive action whenever you can, even if it is after the fact, to go back to the scene and gather whatever evidence you can. Under your PIP benefits, you're entitled to see the doctor of your choice anytime, anywhere. You're not required to seek pre-approval from the insurance agent or adjuster, nor is there a provider's list. It is up to you and your family to decide what doctor you're going to see and when you're going to see them. Attorney fees are paid at the end of the case if there's a successful recovery. A successful recovery is where your attorney has collected any dollars from the at-fault party's insurance company or your own insurance company in some instances. As a result of the collection, you'll deduct the attorney's fees typically at 1/3, which, for example, if we collected $10, the attorney fee would be $3.33. After reducing for attorney's fees, the balance belongs to the client, and from that balance, you may reduce further for any outstanding costs that you would approve. Costs could include outstanding medical bills as well as firm costs. This is a typical scenario that you'll find in any Florida personal injury attorney's office. Our no-fee guarantee not only includes the fact that if there's no recovery in your case, you will not have any attorney fee to pay, nor will you have any attorney costs. So from the standpoint of financial risk, the hope and expectation is that you're hiring an attorney that will not only collect for you an amount that will recover for your injuries, but also an amount that will pay his fees than had you done it on your own. The damages recoverable as a result of your injuries under Florida law include economic and non-economic damages. It's simple to understand the economic damages. Those are the out-of-pocket expenses, the medical bills, the lost wages. Those are the items that are easily calculated. What's not as easily calculated are the non-economic damages. An individual who's been hurt is going to suffer pain and is going to have problems associated with pain, such as sleep disturbance or irritability. The emotions and trauma related to an injury can often be in the non-economic realm. And in fact, it's the non-economic part of your claim that is the most difficult to evaluate. In essence, as a result of your injuries, you look forward for the at-fault party making you whole by paying you for your economic loss as well as the non-economic losses. If you miss time from work as a result of an automobile accident, you're entitled to recover for your lost wages. In the state of Florida, under PIP, or Personal Injury Protection benefits that all motorists must carry, you would turn to your own insurance to collect those benefits, which should pay your lost wages at 60%. In order to collect that 60% of lost wages, we'll need to submit a claim to your insurance company that basically includes a note from your doctor that says take time off from work and a note from your employer that says how much you make. With these two notes, the adjuster at the PIP department for your insurance company will issue a check for 60% of your lost gross wages. If you're unfortunate enough to be hit by someone who doesn't have insurance or their insurance doesn't have the right kinds of coverages, then it's going to be necessary we look at your insurance coverage and what it is that you purchased to protect you and your family. The key coverages that I'm looking for are going to be uninsured motorist benefits as well as possibly medical payment benefits. Those two pieces of coverage are something you should ask your agent to add to your policy today if you don't have them. The reason is because in my opinion, there's a 1 in 4 chance that the cars on the road today, and one that unfortunately may hit your family, could have a failure of insurance. Failure of insurance doesn't mean they're illegal. It just means that they didn't purchase the coverage that's going to protect you and your family. The value of your case is dependent upon several factors, not the least of which is your medical records. In order to properly evaluate your case, we need to know what your doctors say is wrong with you. That's why it's difficult on an initial consultation for me to honestly give a client an opinion as to the value of their case. But what you should consider is, what are the factors that are involved in evaluating a case? It's your medical records, it's what your doctors say is wrong with you, it's what the accident reconstructionists do to recreate the accident to demonstrate who's at fault for the accident, and then of course it's your testimony. What you relate to a jury is wrong with you. Taking into consideration all of these variables helps your attorney put a value on the case so that at some point in the future you'll be able to make a decision as to whether or not settlement offers are acceptable or not. If your car has been damaged beyond drivability and it is in the shop for repair or being considered for totaling, then you should be provided a rental car at the expense of the at-fault party. Generally, this would be paid from their property damage coverage, and generally, the property damage coverage adjuster should set up an account for you at a local rental car company. I wouldn't expect our clients to provide a debit card or a Visa card in order to secure that vehicle. This should totally be paid for by the at-fault party and billed directly to them. Do not give the rental car company your credit card. Expect that the at-fault party should provide you the company, and contact the Soud law firm so that we can make all these arrangements for you. Whether you work or don't work, in my opinion, isn't going to make a difference on your case. And the reason for that statement is because a good defense attorney is going to use whatever he can to make his case. If you're not working, he's going to say that you're lazy. If you are working, he's going to say that you're hurt. So the issue as to whether you work or don't work is one that you should decide between you and your doctor. It's not necessarily going to make a difference in your case, but it could make a world of difference with regard to your recovery. When you're required to use your personal injury protection benefits, a lot of people often react with a concern as to whether or not their rates are going to go up because they're availing themselves of their own insurance benefits. The reality is, an insurance company cannot retaliate against you for an accident that's not your fault, and they cannot raise your rates because of an accident that's not your fault. You're required under Florida law to use your own insurance company for medical expenses and lost wages. That requirement cannot be retaliated against by an increase in your rates. Generally, insurance companies will raise your rates based on your claims history through claims that you have caused. It's also appropriate to have your rates raised when your driving behavior, such as speeding or moving violations, indicate to the underwriters that a rate increase is appropriate. As a result of this accident that's not your fault, don't be concerned about the retaliatory conduct of raising your rates. It's not likely to happen and is against Florida law. The effect on your credit is a real issue for a lot of clients. We can help at the Soud law firm in avoiding those problems. The way that we help is we contact those to whom you owe money as a result of the treatment and as a result of the losses, and we try to mitigate the collection efforts. One way that we can do this is asking the facility or the doctor's office to hold any outstanding balances based on a letter signed by your attorney.